Okay, let's dive into a real legal labyrinth. Imagine a situation, right? You're a victim of a crime, maybe something online, cyberstalking, fraud, whatever.
Yeah.
You go to report it, but the rules are just so tangled up. Nobody's quite sure who should investigate or, which court should even hear your case. One judge might say one thing, another the total opposite, and suddenly, boom, justice just grinds to a halt. Procedural confusion everywhere.
It's a nightmare scenario.
Exactly. So today we're taking a deep dive into this landmark legal decision from Pakistan that really tries to cut through that mess, especially where digital crimes meet traditional law.
And what's really illuminating about this court order is how it clarifies not just what justice looks like now, but how the system needs to work to actually deliver it.
Right, the practicalities.
Precisely. It's about clarity, streamlining things, and protecting fundamental rights. Because, electronic crimes are evolving so fast and mixing with the old penal codes. So our mission today is really to pull out the key insights from this judgment, help you understand what it means for investigations, trials, even your own rights.
And you've given us this fantastic document for the deep dive. It's a detailed order sheet from the Islamabad High Court. The case is Mohammed Ayaz bin Tariq versus the state and another final judgment, June 3, 2024.
That's the one.
And it's not just dry legal text, is it? It's actually a pretty fascinating look at modern law's challenges, packed with surprising detail.
Absolutely. It gets right into the nuts and bolts.
So let's get into it. Where did the court start? What were the big questions?
Well, there were a couple of core issues they were grappling with.
Okay.
First, could the Federal Investigation Agency, the FIA, Pakistan's main cybercrime agency, could they investigate crimes that mixed cyber stuff under PICA?
That's the Prevention of Electronic Crimes Act, 2016.
Yes, PICA. Could they investigate those alongside traditional crimes from the old Pakistan Penal Code, the PPC?
It's the 1860 code.
Exactly. And second, if they could investigate jointly, were those special courts set up just for PICA actually the right place to try these combined cases?
So the investigation and the trial location.
Yes. And this is where things were really tangled up before. There were completely conflicting judgments historically on who could do what.
Like what?
Well, for instance, an older case, Javed Khan v. the state, had basically said, nope, joint investigations are not allowed.
Seriously?
Yeah. It meant cyber offenses went to one agency, traditional crimes to another, even if it was all part of the same incident.
That sounds incredibly inefficient.
Oh, it was.
Like trying to solve a puzzle but giving half the pieces to one person and half to someone else, and they can't even talk.
You got it. It risked parallel investigations, parallel trials, maybe even contradictory results for the same set of facts.
That's madness. Imagine being the victim in that situation.
A total nightmare. Creates a huge procedural mess for the whole system.
Okay, so that's the problem. How did the court start untangling it? Especially this issue of where the cases should be heard. You mentioned these designated courts.
Right. So before this judgment, the government had designated specific courts for PICA. And the ones they chose were these special judges appointed under a really old law, the Pakistan Criminal Law Amendment Act of 1958.
Okay, 1958.
Okay.
And that act has its own list of crimes it covers.
Exactly. It has a specific limited schedule of offenses its judges are allowed to try. And here's the kicker. PICA offenses were never actually added to that 1958 Act schedule.
Wait, right. So the judges designated for PICA couldn't legally try PICA cases.
That's the fundamental flaw the High Court found. Despite being designated, they lacked the actual legal competence. Because under Pakistan's constitution, a court only gets authority if the law explicitly gives it. And here, it just wasn't there for PICA offenses under that 1958 framework.
Wow. So it's like giving someone a job title but forgetting to give them the actual authority or tools to do the job.
A perfect analogy. Their PICA-related rulings were essentially built on shaky ground, legally speaking.
So if those special judges weren't the right ones, who did the court say should be handling these cases?
The court was very clear. It said PICA itself actually points towards trial by ordinary criminal courts.
Meaning?
Meaning the regular courts already dealing with criminal matters, like senior magistrates, specifically those empowered under Section 30 of the Criminal Procedure Code, or CRPC, and sessions judges or additional sessions judges.
Okay, standard courts.
Exactly. The judgment emphasized these courts already have the competence, based on the punishments they can hand out, to try most PICA offenses anyway.
And why is sticking to these ordinary courts so important? Is it just simpler, or is there more to it?
It's absolutely vital. It protects a citizen's fundamental right to appeal.
Oh, okay.
The court called the right to appeal an integral part of the criminal justice system. It even mentioned that Islamic principles mandate at least one appeal as a right.
So if only specialized, higher courts heard PICA cases from the start.
You'd lose a layer of appeal. It would make a specific part of the PICA law, the bit that guarantees an appeal, basically meaningless. And courts really try to avoid interpretations that make parts of a law redundant.
Makes sense. Okay, so the court fixed the who tries the case problem. What about the can you try mixed offenses together problem? How did they tackle that?
Right. Can you investigate and try a cyber element and a traditional crime together if they're linked? Here, the court relied heavily on a principle already set by the Supreme Court of Pakistan in a case called Shuran Bibi v. the State.
And that principle is?
Basically, only one criminal case shall be registered in respect of one occurrence offenses committed in one transaction. One incident, one case.
One transaction. Okay, but what does one transaction actually mean in legal terms? That sounds a bit vague.
It can be, yeah. So the court looked at precedents to clarify. It's not just about crimes happening at the same time or place, although that helps.
Right.
The really key tests are, one, is there a continuity of action? Like, do the acts flow together?
Okay, a continuous flow.
And two, is there a commonality of purpose or design? Is there a shared goal behind the different actions?
A shared objective. Got it.
If you have those two things, continuity and common purpose, that's usually enough to link different acts into the same transaction.
So it's about the story of the crime, the whole narrative, not just isolated bits.
Exactly. And the court found that recent changes to the law, specifically amendments made in 2023, really supported this view.
The plot thickens. What did the 2023 amendments do?
They were crucial. The Criminal Laws Amendment Act of 2023, particularly Section 30 of PICA, clarified something important.
Which was?
It explicitly said that both the FIA and the regular police are authorized to take notice of PICA offenses.
Both agencies, okay.
Now, the police still have to refer the technical cyber bits to the FIA, but, and this is key, the amendment doesn't stop the FIA from investigating related traditional penal code offenses alongside the PICA ones.
Well, longest.
As long as they stem from the same transaction and the traditional offense is something the FIA is already allowed to investigate under its own act.
So this directly contradicts that earlier Javed Khan ruling that said no joint investigations.
Absolutely. It explicitly overrules those previous conflicting judgments. It says, yes, you can investigate and try these linked offenses together. Put the puzzle pieces back together.
Okay, this is making more sense. The court used a hypothetical example, didn't they, to show why this matters so much in practice. The hacker one.
Yes, the hacker example, it really drives the point home. Imagine a hacker gets into your social media account.
Unauthorized access, that's a PICA offense.
Right. And then using your account, they post blasphemous material.
Which is a very serious offense under the Pakistan Penal Code, the PPC.
Extremely serious. Now, the court highlighted the stark difference in outcomes depending on how you handle this.
How so?
Well, if the investigation and trial for both the hacking PICA and the blasphemy PPC are combined, treated as one incident within the same transaction, then the system can work. The investigator, the court, they can see the whole picture. They can figure out who actually posted the material, likely the hacker, and bring the real culprit to justice efficiently.
Okay, that sounds logical.
Okay.
So what happens if they're separated, like under the old conflicting rules?
If they're separated, the judgment calls the outcome catastrophic.
Catastrophic. Why?
Because you, the victim whose account was hacked, could paradoxically end up being accused of blasphemy by the police.
What? While you're trying to report the hacking?
Exactly. You could be facing a police investigation for blasphemy, while at the same time, you're the complainant with the FIA trying to get the hacker caught.
That's terrifying.
It gets worse. The court pointed out you could even be convicted of blasphemy before the separate FIA investigation manages to prove you were hacked in the first place.
No way.
Yes. It leads to fragmented evidence, different agencies possibly reaching opposite conclusions on the same facts. The court said it would create anomalous situations and make the whole legal framework unworkable, a total breakdown for the victim.
That example really shows why joining them up is crucial. And it also clarifies something else, doesn't it? Just using a computer doesn't automatically make a crime a cybercrime.
Correct. The court was very careful to stress that. The mere use of an information system like a phone or computer, to commit a standard PPC offense doesn't magically transform it into a PICA offense.
So you still need to meet the specific definitions under PICA.
Exactly. You need the specific criminal act, the actus reus, and a criminal intent, the mens rea, as defined in PICA itself. But if those are met, and a related PPC offense happens in the same transaction,
Like the hacker example.
then yes, they can and should be investigated and tried together by a competent ordinary court. It's about the nature of the acts, not just the tools used.
Okay. Now, before we get to the final directives, there was this other legal idea, the de facto doctrine. What was that about?
Ah, yes, the de facto doctrine. It deals with that earlier problem we discussed, the special judges operating without proper jurisdiction for PICA cases.
Right. Does this mean all their past PICA judgments are now invalid? Because that sounds like it would cause chaos.
It absolutely would, and that's precisely why the de facto doctrine exists. It's a legal principle that basically says actions taken by someone in a position of authority, even if their appointment was technically flawed or illegal.
Yeah.
Those past actions can still be considered valid if they're finalized, if they're past and closed transactions.
Right.
To prevent exactly that chaos, to protect the public interest and avoid having to undo potentially thousands of settled decisions. Think of it like if a judge's appointment was found faulty years later, you wouldn't necessarily reopen every single case they ever decided if those cases are long finished and appealed.
Okay, so it protects finalized decisions made in good faith, even if the authority was technically lacking.
Sort of, yes. It's about stability and practicality. So applying it here, the court said that while the special judges did lack jurisdiction for PICA, any PICA judgments they issue that have already attained finality, meaning they're done, appeals finished or time barred, those judgments are generally protected by the de facto doctrine. They stand.
Okay, that avoids upending everything. But what about ongoing cases? Or recent decisions?
Critically, the doctrine does not protect pending matters, and the court specifically singled out bail applications.
So if the special judge dismissed someone's bail application in a PICA case,
that order was declared devoid of jurisdiction and set aside because the judge didn't have the authority to make it in the first place regarding PICA. Those bail petitions aren't considered final in the same way a full trial judgment is.
Got it. So past final judgments stand, but recent orders like bail dismissals are wiped clean.
Essentially, yes. Those bail cases are now considered pending again.
Okay, so pulling all this together, after navigating all that complexity, what were the final concrete declarations from the Islamabad High Court? What's the new rule book, basically?
The court laid out 5 very clear declarations to fix the system. 1. Joint investigations and trials are permitted. Agencies like FIA can investigate PICA, PPC, and other offenses together if they're part of one transaction, and the ordinary criminal courts can then try them jointly. Big change.
2.
2. Special judges under the 1958 Act do not have jurisdiction for PICA offenses unless PICA is formally added to their schedule, which it hasn't been. Their past authority was flawed.
3.
3. Ordinary criminal courts are the proper venue. PICA cases go to senior magistrates and sessions judges, and the government was ordered to officially designate these judges within 2 weeks of the judgment.
Wow, a deadline. Okay, 4.
4. Past, finalized judgments from those special judges are protected by the de facto doctrine. No mass reopening of old cases.
And then 5.
5. Those bail petitions dismissed by the special judges, they're set aside as being without jurisdiction. They're now considered pending before the newly designated ordinary courts who have to decide them properly.
That is incredibly comprehensive. It really seems to cut through years of confusion and conflicting rulings.
It's a massive clarification, yes. A significant step towards a more streamlined, coherent system, especially for handling crime in the digital age.
It feels much more logical and hopefully fairer.
Indeed. And this judgment really highlights something fundamental, doesn't it? Legal clarity isn't just academic. It has huge practical effects on investigations, on trials, and on people's basic rights.
Absolutely.
It's about making sure justice isn't derailed by procedural tangles or confusion over who's supposed to do what, especially when technology keeps changing the game.
So what does this all mean for you listening? It shows how vital it is for legal systems everywhere to adapt to new challenges like cybercrime. This deep dive demonstrates courts actively working, even within complex laws, to ensure fairness, efficiency, and consistency, cutting through the noise to find a clearer path.
And maybe consider this. As our lives get more digital, how could other countries learn from this? This idea of joint trials for same transaction offenses using ordinary courts. Could that be a model for better efficiency and victim protection elsewhere as cyber and traditional crimes merge?
Yeah, it's a really interesting question to think about, how different systems are tackling this convergence.
Definitely food for thought.
An excellent thought to chew on. That's all for this deep dive.